I want to use the opportunity, as always, when I speak, to highlight the existence of the Blockchain Bundesverband. Just a quick question. Is there anyone in the room who is not aware of the existence of the Blockchain Bundesverband yet? Still a couple of hands. Yeah, so we formed the Blockchain Bundesverband in June this year. Basically about 20 blockchain startups together with 3 universities and a couple of people involved. And the goal is to get blockchain mentioned in a positive way in the next coalition agreement after we voted all in September. Because the politicians we talked to so far, they all told us, if you don't get it into the coalition agreement, the next 4 years, nothing will change. So that was a one-time opportunity, and we formed it very quickly and have now about 20 working groups up and running, which are open to everybody in the community. So everybody who would like to contribute is heartily invited to join. And this time, I actually got the list of our working groups just to give you a flavor of what we are all looking into. So we've got an important working group on digital identity. And then we've got supply chain, legal services and legal tech, sharing and collaborative economy, smart cities. We've got Industry 4.0, connection to smart X IoT devices. That's actually an interesting group. It's a little bit cross-industry. We've got voting infrastructure, tokens, crypto economy, ICOs, that group, I'm heading that group actually. Energy, finance, insurance, science and healthcare. I saw Sönke, where are you? He is actually heading those 2 groups. We've got real estate, Achim is heading that working group. General legal framework, that group is taking care about questions surrounding closing contracts and general terms and conditions, disclosure requirements, things like that. And then we've got privacy and data protection, obviously, another big issue. IP and licenses, we've got a corporate law group. Daniel? Raise your hand. Ah, yeah, right in the back. So he's actually heading the corporate group. Tax accounting, also very important. And then we've got a couple of groups which are not really working on identifying pain points, which we want to present to the politicians, but on pilot projects. That includes a collection of projects we can actually present to the public authorities to play around with blockchain solutions themselves. So whoever has like a project going on which could apply in that sector, get in touch. I think they are working currently on the car filing, Kfz-Zulassung, which they are looking out for a couple of communities which are willing to play the blockchain solution a couple of months alongside the traditional way of doing it. And then obviously they are looking into real estate, land register, things like that. And then we've got education, what is very much at the heart of one of our managing board members. So we're trying to partner up with universities, and we've got a group, ethics and governance, which is looking into the typical governance problems, especially with the public blockchains. So if any of those topics are of interest for you, get in touch, and we gladly integrate you in our working groups. So that was it for the Bundesverband. And so I hand over to Arnab to give it a start with our presentation.
Hi, thank you, Nina, and thank you, Sven, for inviting me also over here. And I think if we are working as a community and you all want a community to come up, I think this kind of working groups is very important. And please participate, even if you can give maybe a few hours in a month, that's also useful. So please consider it as an option. Please join. Now coming to the question on ICOs and what are the legal issues and non-legal issues, whether you should be afraid or not. There are some differences between me and Nina also and other people also. What are the classification of tokens? Some say classification has to be done purely on legal aspects. Some say it's an economic aspect, because you have to come under very atomic level on what are the classification grounds of an ICO tokens. So I have classified it under 3 categories. One is purely utility token. That can be both payment tokens and a non-payment tokens. Then you have a non-utility token, which has no utility, but you just use it for maybe an asset backed, or there are hybrid tokens, which has both utility as well as an asset function. Now, when we can see the SEC order came and everything, it's a very interesting moment when it just about to cross 1 billion market in the ICO field, then SEC came in. After SEC, all our regulators, they are best friends to each other. They started copying and pasting. It's a very good plagiarism model, and they're using it properly. And there's also issues whether the SEC ruling is an executive order. First of all, it's not a court order, so it's not a law. It's just an executive order. And an executive, and it's also a report. It's not even an order, it's a report. And whether the report has covered all the legal aspect. What I personally also feel on certain aspects that they have talked about initially about investor security, and when later they came in the end of their report, they've lost the space of investor security and how to protect with this 1800s judgment and those kind of ruling without going into any jurisprudential aspect of what is investor security, who are the investors. Very few tokens are securities, and what about the other tokens and what are those securities? Now coming to the question whether it's, so this is this market which I got the information from Autonomous. They did actually very good job by analyzing it in a proper graphical way, and you can see it's like 1 billion when it started to reach, and they said, okay, now we need to come, the SEC thought. Now what are the issues? What are the issues that we should talk about the ICOs? Is it only about securities law, or there is something else? Securities law is one part. If I am considering about the European legal aspect, there are MiFID regulations and there are other aspects which can be of useful for the European legal aspect, and I think Nina will talk about this in later slides. The other aspect which is very crucial is the consumer protection law. A lot of projects are promoting in such a way that they will solve the problem, the world problem in a second. Just give them money. And they are selling, okay, you give me money, I will give this benefits. If they do not do, if the projects go bankrupt, like if they cannot do, they say, okay, then you lose your money, but in a very small terms and condition. I did an interesting research right now. I tried to find whether the ICOs, after the ICOs happen, they put the terms and condition on their website. Most of the projects, they do not. Why they are afraid then? Why they are not putting the terms and condition on the website? If they are so much about decentralized, full of transparency, why there is a lack of transparency in this aspect? The second coming is the data protection law. A lot of projects are taking data in the pre-ICO stage, in post-ICO stage, both. What about the data? How they are controlling this data, the personal information and everything. The PR activities, how they're happening at this point of time. No one knows who are the PR agencies, how the PR agency collecting data, and this is a very crucial aspect. What PR are representing, sometimes the tokens are not. The VAT law, Nina will come on this aspect. If it's a product and if you're selling a license, say, okay, this is a IP product, so there was a VAT obligation, how they're going to fulfill all those obligations. Creating an ICO vehicle in some weird jurisdiction doesn't help you. First of all, if you want to also survive in the market, and in order to replace the VC also, you have to have some credibility. Without credibility, without face, you are actually ruining the market ecosystem. There are a lot of good projects, a lot of good coins, but there are also a lot of shitty tokens and shitty projects, and people knows it. And we have to weed those projects out, and it's a community initiative that should come into play. Now I would like to give to Nina to discuss further.
Thanks. Yeah, and well, let's take a deeper look into what are tokens, what do they represent, and how do we lawyers actually try to enter into that topic. Now, first of all, there is currently no robust infrastructure where you could get like the ICO off the shelf. There's no developed market, no developed documentation, no developed procedures so far yet. A lot of the ICOs we've seen so far had maybe not been truly legally structured. I completely understand that because it evolved from a different world, and sometimes in early stages also with the claim that this whole thing is outside of the legal environment because it's just code, but actually it isn't. So what we do is we always try to get to the content of the token as such. We are trying to look through this digital something and understand what the token actually represents. And the typical thing which it represented in case of Bitcoin is a cryptocurrency. So cryptocurrencies are tokens which come along with payment, which are used for payment means between different parties, and which allow actually to measure the value of the purchased good. So it makes the price comparable. There is now a current suggestion in the amendment for the 4th anti-money laundering directive on EU level. That's actually the first one within the EU trying to bring a definition for what they call virtual currencies. And if you read that, digital representation of value that is neither issued by a central bank or a public authority, nor necessarily attached to a fiat currency, but is accepted by natural or legal persons as a means of payment and can be transferred, stored, or traded electronically, then I guess you get immediately that this is very broad, and everything that within the blockchain community would be seen as cryptocurrency is clearly captured here. So that's not in place yet, but we expect, I don't know, maybe by the end of the year, that this European directive will come into place, and then we have a definition for the phenomenon of cryptocurrency. That's one sort. But a token can represent way more, and you mentioned already, and you as well, a couple of those, shares, financial instruments, licenses, vouchers. And for all the different types of assets that are represented by a token, different civil law and regulatory law regimes apply. So when we take then a look into the main categories that we've seen, we actually working on an analysis of ICOs within the tokens and ICO working group of the Bundesverband. And the most relevant categories from a legal perspective, that's not a typical, classification you would see within the blockchain world, but from a legal perspective, the most relevant categories are cryptocurrencies, as just mentioned, then the equity tokens. And equity tokens we always understand as a token which come along with profit participation rights plus voting rights. So if that comes in combination and the voting rights go pretty far, especially like include things voting on the profit distribution or voting on electing managing directors, things like that, then you're very close to an equity token. We in Germany then have this third category, profit participation token, which from many other jurisdictions will be simply another class of equity tokens. But we in Germany actually distinguish between those two. The profit participation tokens usually only come along with the profit participation right, but no, or at least no substantial voting rights. In the finance area, where I come from, we would call this MES. It's a mezzanine financing. It's not an equity financing. And then, completely different from those three, who are all kind of financial instruments, are the next two. Software tokens, or software license tokens, which we would call tokens who simply grant access to the use of a software or a software environment. Might be a platform that you're creating. And asset tokens, which represent either try to represent the title in a tangible asset or at least the economic value of a tangible asset. So something you can actually grab, real estate, cars, diamonds, whatever. Those are clearly no securities from a German perspective. They are out of the financial regulatory regime, but with those tokens, you're right into the VAT problem. Because VAT and that's the same as the regulatory regime, always applies, at least in Europe, where the user is located. So as Arnab already mentioned, it doesn't matter from where you start an ICO. It rather matters where you offer the token, right? The jurisdictions where you offer the token, that are the jurisdictions that are relevant for the regulatory view and, at least with regard to VAT, also for the tax perspective. So what is a token as such, disregarding what it represents? We in Germany have like a fixed number of what we call absolute rights. And those are basically receivables and assets, like physical assets. And obviously the token is neither one, right? You don't have a right against a third party purely out of the token, and you cannot hold it in your hands. So the problem is that in Germany, this thing token is not protected by law as an absolute right. We would call it rather sonstiger Gegenstand, other object, which exists and which is acknowledged by civil law. For example, the sales contract provisions apply accordingly to other objects, but it would be rather called exchange, not sale. Yes, it's comparable to something like know-how, right? Know-how is also one of those things. So we actually can deal with it from a legal perspective, and you can transfer it. It's merely on a contractual basis. There's no in-rem protection, right? That's one of the issues we want to address, because if that spreads, especially within consumers, we think the legislator should think about applying some kind of absolute protection to tokens as well. And then you've got actually to differ from the transfer of the electronic token, the transfer of the asset that is represented by that token, because there might be different rules applying to that. So actually you can only really attach something to a token if there are no specific form requirements for transferring the represented asset, right? Because otherwise the transfer, for example, real estate, you can only transfer by getting an entry into the land register. If you don't have that, you don't get the title to that property. So you can't simply transfer real estate by the transfer of a token. So I know that there are a couple of groups currently trying to make up their mind how to solve that issue. And that's simply due to the fact that in a lot of cases, statutory law mandates certain legal benefits only when certain requirements are met. That's not only the case for property, for land, but also, for example, for shares in limited liability companies, or for KGs, limited partnerships, because all those entities require that you go either to the notary or you get an entry into the commercial register. So those things are also difficult to truly attach to a token. And then you always, if you have a real world asset attached to the token, you always have to think about the possibility that this object might be acquired in good faith, right? So if we're meeting on the street and I'm saying, here's my microphone, do you want to buy my microphone? And you're saying, oh yeah, have 10 euro, and I hand it over to you, then you're protected because I hold the asset in my hands, and you can actually acquire it in good faith because I hand over to you the asset itself. And then it's gone, even though maybe the token is still mine and I can sell the token later the day to somebody else. Those things are also to be kept in mind when you're thinking about attaching a real world asset to a token. Same thing, for example, if the other way around, We're having a nice party later on here. I'm drinking a couple of beer. I'm completely drunk when I get home, and then I spread my tokens. From the civil law point of view, I can claim them back the next morning, right? Because I was like out of my mind at that point in time. In that case, the token might also not represent what it claims to stand for. Aside of those issues, we've got another one, which is a huge one, actually. That is the multi-jurisdictional challenge. There is no such thing as an overarching, unified, legal, global system. Unfortunately, jurisdictions are broken down to countries. We have like 192 countries around the world. We have multiple bilingual, bilateral or multilateral legal agreements. Think about it, the EU alone, what massive number of regulatory rules we have here. So unfortunately, the legal world is splintered in lots of fractions. And it's not possible, really not possible, to observe any and all requirements we have around the globe. So anyone who wants to go global needs to start with core jurisdictions, try to figure out how things work there, and then slowly expand. That's what, you know, any kind of international company does when it's going to offer its services or products abroad. There's nobody who's able to actually start on a global basis right away. And I really like that sentence from Stephen Paley, who said, distributed presence means distributed legal liability and distributed compliance, and I added tax obligations. Businesses with international operations are well acquainted with this. That's unfortunately so true, and there's no way to get around this. So be mindful of the multi-jurisdictional challenge. Check where you actually offer your token. It's even more important than checking where you're located. Carefully choose the governing law where possible. In principle, in civil law area, you can choose the law that applies to your contracts. But there's always some mandatory law in any jurisdiction where you offer the tokens which will overrule your contract, like, for example, consumer protection laws, data protection laws. Obviously, the whole regulatory area is nothing that you can opt out by choosing another jurisdiction. Yeah, regulation. Regulators start to take action. We see more and more regulators voicing their opinion, their maybe first slight opinion about the token world. In Germany, BaFin already said a while ago that they would see cryptocurrencies to be so-called units of account, Rechnungseinheiten. And that is actually a financial instrument pursuant to our banking laws. That actually differs from more or less the rest of the European Union, interestingly enough. And it basically means that the commercial trade requires a license from the BaFin. I already mentioned the upcoming amendment of the 4th EU Anti-Money Laundering Directive with its new and first definition of virtual currency. And what it will actually bring into the field is a full KYC obligation for gatekeepers. And gatekeepers are wallet providers and crypto exchanges. So that will be coming soon in the EU. Then the EU discussed already a while ago, I think it was earlier this year, whether they should restrict the allowed volume for payments with cryptocurrencies. Most of you will know that cash payments in euro are already restricted and limited. And there were discussions going on whether they should extend that to cryptocurrencies as well. Seems a little bit difficult, to be honest, because how do they want to control it? So that seemed to me a rather theoretical approach. but we'll see what they do. Then we saw the SEC report on the DAO, basically saying that those are securities and that they watched it closely. They even mentioned, you know, the names of people involved, what I found really surprising. And the cryptocurrency exchanges in the US seem to start to react on that now, because qualifying that as security means that they either need to delist those tokens from their exchanges, or they need proper license, what not all of them currently have. Then the MAS Singapore followed SEC rather more or less immediately, and also clarified that they are going to regulate tokens. And I am aware that BaFin also is working on a paper. They are not saying when they are ready to publish it, but they are working on further announcements, so we'll maybe see that sooner or later this year.
Oh, thanks. So I will just add to Nina's list. Canada also came up with a paper recently on ICOs and how the investors should be careful. FINMA from Switzerland is planning maybe this week or in 2 or 3 weeks, we will see something. Now I'm coming from a legal academic side, so she is a lawyer, she follows very law strictly. But if you understand a very basic principle, there are 3 questions of regulation. What to regulate, who should regulate, and how to regulate. The first and the last question, and what and how, these are often discussed. These are discussed in every legal text, every legal jurisprudence. But who should regulate? This is a very long debate in jurisprudence, in legal jurisprudence. And a concept of regulation, whether it should be decentered and centered regulation, that comes into play. And I think when we're talking about decentralized market and decentralized economy, why not a decentralized regulation structure? The concept of nirvana fallacy, have you ever heard about this idea of nirvana fallacy? Anybody? Okay. So nirvana in Buddhist concept means you have achieved like the ultimate stage of enlightenment. In legal aspect, there is nothing that is, even if you have done everything legally correct as per your lawyer, they cannot guarantee this is absolutely correct. Because at the end of the court says, okay, this may not be. So the nirvana fallacy works like, even if it's not perfect, it should be workable. How we should make this ICO market workable? Now that's the question, because this market has grown and this will stay, this will not grow. It will evolve. So how we can contribute in the evolution? I think the entire idea of this meetup was how it can influence the corporate structuring and corporate financing. And I think this is a very interesting discussion of self-regulation. The self-regulation doesn't mean what we regulate or individual self-regulation, but it's a collective self-regulation. Collective means the community as such, how it can regulate. And the understanding of a decentered regulation means the regulation is not a privy of a state, that is the nation state or the government should not be the only regulatory agency, but the civil societies, the participants, the businesses as such must also have a say. And I think this say need to be channeled through associations like Bundesverband and other associations. They should come together and create forum in a hub and spoke model, not in a very understanding like you should not make a clear-cut distinction, okay, I am US, I am an association from Russia, I am an association from Germany, but a hub and spoke model where they both all collaborate, and then you move to some agencies like IOSCO, which is an international organization for SECs, and ask them, hey guys, look, we have something, please give us an opportunity to place before you, and let's discuss on a mutual collaborative way whether it can be done or not. And this should come on a very transparent model. Now, how we can propose this kind of things can work. So the community should come up, what I can understand, by a code of conduct. Like what should be the ICO's best practice, or what should be the ICO projects do, what the investor should see, what the projects must implement. And that's the community must bring out those things. Then you create those ICO rating agencies which are already there and ask them to implement those. Create dialogue, a proper transparency dialogue with the Securities Commission or your government, and then you can achieve a decentered regulation because you have already told them what you have done and there's a full transparency. There may be a lot of issues, it sounds very complicated, it is complicated. actually. And that's why all the civil society and all this society of blockchain should come together on this aspect. I've just given some examples like engineers, lawyers, all these agencies, they have actually created their own self-regulation body, and they are being monitored by the self-regulation body. Why not this blockchain actually can also come up with some kind of self-regulation body which also regulates the best practice code? There are two fixes, one that can be done on a short-term basis, one that can be done on a long-term basis. The long-term basis is to create a best practice standard. So you have understanding how it works, you have the regulators on board, and you are not afraid. And also this, you can weed out those shitty coins. For the short-term fix, immediately the project proponents, if I have seen, like there are certain measures that project proponents or the ICO projects must put into place. First, have a proper legal advice. Without creating a legal structure, please do not do an ICO and mislead the people. There are a lot of ICOs they are doing without having any legal structure. They do not tell where the money goes, they just focus on Facebook and other PR activities. It should not be done. Not merely a white paper of 5 pages. At least something, some workable model should be there. Even if you don't have an MVP, at least have some MCP. Wallet security, who is in charge, whether there is security auditing, those kind of things must be taken into consideration. Whether there is an independent auditor, like where the funds, how the funds will be utilized, whether they have a business plan, all these things must come up and see how detailed the information is in the white paper, their utilization model, their project model and everything. The business report of for the contributors. This is one key important aspect. I think if the lawyers are here and this is an auditing requirement also, you give in a fiscal year, there is a report, auditing report. Why not we also put some kind of business report, like how you have burnt the money and put it on your website. Be transparent to the projects and to your contributors. For the contributors, there are a lot of things that need to be checked into. First, they have a hard cap or not. If there is a hard cap on capital, that shows that they did their research, they know how much they want. They do not want to go to the moon. Then you also have, is the code an open source or not, whether it has been done, if it's not, whether there is security auditing, who has done the security auditing. This kind of questions must be asked. Business roadmap and technical roadmap, very important thing. Disclosure of team members, a very crucial point. A lot of projects doesn't show who are the real beneficiaries of the project. And community must ask who are the real beneficiaries. There's another trend which I have also noticed these days is they show partners of the projects. Sometimes after 1 week or after the ICO, the name of the partners disappear from the website. So try to see whether they have linked the partners from their website to the main partners, and also whether they are actually going publicly and asking, okay, these are the partners, and please cross-verify and try to ask them question, do you have an MOU with them? If not, how you can say you are a partner? Those kind of things. Now the responsibility in a decentralized regulation, I have classified under 3. There are main 3 actors. First and foremost is an exchange, and we have one of the biggest exchange sitting over here. And the exchange guys have the most important, I think, risk also, because they are the reason that ICO also flourished, because they provided the secondary market and the hope for the secondary market. So when they should list the tokens, they should be very careful whether the tokens are securities or not. If they are, what are the legal requirements they have taken? Whether the project that came to get listed, whether they have a legal structure or not, those things. The project owners must first create a legal entity who should be in liability of the tokens and the funds, and also be transparent to the community at large. The rating agencies, these are the agencies that need to develop. There are already some rating agencies, but I do not know that they follow a universal method or not. But they should come under certain criteria. The first and foremost criteria of the rating is the transparency. How transparent the projects are, how the informations are there, and what are the investors' protection or the contributors' protection, so as to say. The novelty of the project, the fund management team, or who manage, and what is the management plan, the business plan and technical plan, and also a legal structure behind the token issuing company, and who will be the ultimate beneficiary. Because number of these days, the token issuing company is some foundation, then the beneficiary is some corporation. Who is ultimately liable? This kind of things should be written very clearly in the white paper. I think Nina can now forward with the other presentation.
Yeah, I think We're summing up. Maybe there was one thing I was thinking about, Alex, when you spoke. You said the VC funds are more, long-term oriented investors, and I read an interesting post, and that also comes back to what you're saying. Best practices, actually. For an ICO, to prevent these pump and dump schemes, the tokens should be locked for a certain period after the ICO. And personally, I also think, if you're participating in a pre-ICO with a huge discount, your lock-in period should be even longer. But that's my personal view, and that would be, I think, an easy fix to a couple of those schemes we're currently seeing. Yeah, but. To round it up, legally relevant are is basically everything that you state to sell your ICO. That certainly includes the white paper. And let me say this: a lot of white papers are a little bit formatted as if they were prospectuses, and I think you shouldn't do that. Either you write a proper prospectus and get the approval of the regulatory authorities, or don't make your document look like a prospectus. That's one thing. And especially if you're selling like software license tokens, there is no reason at all to make something that looks like a prospectus. So I really would recommend doing a proper analysis and then setting up documents that actually contain what they should contain. Then you've got typically a purchase subscription agreement, and the terms and conditions, those are sometimes combined. And independent of the form, those documents are legally relevant, right? Even if it's just in code. Determined content of legal relationship with user, yeah, remember substance over form. Really think about what you're offering and understand the legal environment in which you're playing your game. Not only the environment where you're located, but as we mentioned already a couple of times, where you're going to offer your ICO. And then the rest is the typical things, obviously, if you get in conflict, especially with the regulatory laws, you're threatened by fines, even prison. And obviously, we will see sooner or later claims for damages by investors coming up. And then if you're actually going to prepare an ICO, I would always recommend, no matter what type of token you issue, that you discuss it with a BaFin beforehand. You can actually get in touch with them via their online contact formula, and they will get back to you if you do it properly, typically within a week or two, giving you a call to discuss it. And then they will ask you to hand in the drafts of the contracts that you're going to offer to the public, and only following that they will maybe give you like a written statement. But the call typically gives you already a good feeling where you're at. And maybe some further tips: really work out your request to the BaFin properly so that they can understand the legal structure behind it. Don't copy white papers, right? They have seen so many, they will recognize that you just copied it. So don't do that. They get so bored with these things. And don't hide away anything from the regulators. Doesn't make any sense. They will follow you. They will look what you're actually telling on social media and compare it to that what you discussed with them. So it doesn't make any sense to try to hide anything you intend to, tell the wider public. Yeah, that are my closing remarks. Thank you very much.
Yeah. So, are there any questions? Or if there are any questions, then raise them. Yeah, we have some here, up front. Yeah, just wait, because people would like to hear it also in the back, and we are, by the way, also recording.
Yeah, this is a question for the lawyers. You said multiple times about you have to consider where you are offering your ICO. and it's not about where you are formed. So let's say I form in Switzerland, and I have a website, and people go there from I don't know where. They read the documentation, and they take part in the ICO. How am I supposed to know? Let's say I get, you said it's 192 countries. I get 192 people that sign up, and I must then spend, what, all my ICO money to adhere to the legal regulations in 192 countries? How does that work?
So Nina, what you say?
Yeah, it's actually very simple. You're only supposed to make your offer where you can legally offer what you offer, right? It's your responsibility to check where you are allowed to offer your tokens. That's not the responsibility of the people around the globe to singly check whether they could actually legally buy into that. So that's simply the way it is. Wherever you want to offer a service or a good, you as a seller need to check if you comply with the local laws. And unfortunately, yes, in the digital times, you know, you can simply host a website and offer it globally, but that doesn't help, right? You nevertheless, even though the technology enables you to do a global offering, you nevertheless are requested to take a look into that. And for the US specifically, the recommendation I hear from the US colleagues is really to block the IP addresses, to set in your general terms and conditions the questions to confirm that you're not a US citizen, to tick the box, to really make sure that you're not offering that where you're not supposed to offer it.
Then what percentage of ICOs, current and also past, do you think have been compliant?
Not very many. No, we are just seeing right now, and I think there are a lot of professionals out of the legal, tax, and audit field trying to work out proper structures right now. And we're seeing more and more teams who really want to be compliant and are taking time and effort to actually sort those issues out. But you will nevertheless see tons of more ICOs which simply do not care.
Okay. Oh, another question? Dave?
Yeah. I have a question. If you personally think that the free market should adapt to laws, or if the laws should adapt to the free market?
I like that question. Actually, honestly, if I would have, when I decided to study law, if I would have thought about the fact that I would, bind myself to a single jurisdiction, I would not have done it, right? So, that conclusion came too late for me. So, the jurisdictions, the multiple jurisdictions across the globe are create a lot of challenges, but I would not go so far that I would say a global law would be perfect, because then you would not have any choice, right? Currently, you at least have the choice between different approaches. You can choose where you settle down. And some law regimes might not be something that I would actually choose to be governed by. So maybe a completely unified global law is also a dangerous thing. But I completely agree that we currently certainly have too many of those.
Maybe the specific issue you mentioned just now, do you see that change in the future with the developments in the blockchain space? So like smart contracts are basically like self-executing law. So there's people that are saying, we're in a transition from a lawyer capitalism to a programmer capitalism. Do you have any comments on that, or what do you think?
Law is like language, right? It's not a mathematical science. Hence, we deal with a lot of gray areas. And that's always difficult for a code to get along with gray areas. So yes, we can surely make law more effective by using smart contracts, but smart contracts will never ever be capable of actually solving all problems. There will always be gray areas which you cannot foresee in a smart contract.
Something? Like we lawyers, like even Nina, she has a bar license. When she advises, you are meant to presume that her advice is perfect. Does the coders have it? Do you have an agency that says this coder can be reliable? No. First, you should ask for your own agency. Like that's, I think the coders should have an own self-regulating agency that says, okay, if you go to this coder, that coder's smart contract can be reliable, and DAO like HAPCO will not happen. Okay. Another thing that comes is a smart contract. It's the script language, right? It just modified. Something else may modify in 5 years. You cannot say an age-old tradition or the profession changes completely. What is like how it can be adopted in the economy? And I think that's the different question. Another question on free market economy, which he asked, are we really staying in a free market right now? I don't think so. This is not a free market, which we have with all the WTO things going on. So if the nation states still exist, so we have to work out how we work with the nation states and how the municipality, when we come, because now municipalities or the states or the cities, they are becoming powerful. How we collaborate this nation state and cities, that's the important question. And this is the question of free market also. And it's a very theoretical question, sorry for that. Okay, any questions?
What about insider trading? I mean, how are ICO investors actually protected by any law according to insider trading? I mean, I get it that it's valuable that we talk about like regulation of ICOs, but nevertheless, once you have an ICO that's completely compliant and people still mess around with like massive insider trading, how does that fall in place from your opinion?
Depends, I would say. If the one who's messing around is the one selling the token, I could see some claims by, you know, the investors being cheated coming up. It certainly depends. You know, the problem currently for Germany is that our definition of securities deviates from the EU definition. That makes it quite difficult because the German securities always require a paper to be issued. So none of what we would call Wertpapier can be tokenized currently in Germany, right? The EU definition is wider. And interestingly enough, we will have 2018 another EU prospectus directive coming up, which will apply directly in all the member states. And that will introduce also to Germany that wider securities definition. And then, you know, we can also see this insider trading rules which apply to securities being applied directly.
Given, I don't own any tokens yet. I come from an old school financial environment, and I'm looking at all a little bit more real world objectives. All I've heard is a lot of better questions I would have asked too. One thing I really don't understand is we're talking a lot about how we're gonna want to self-regulate and it's all beautiful. I just don't think it's viable because human nature is just not done that way. We all need, somebody always wants to be in control. I mean, the current CFTC in the US just allowed the first Bitcoin swap. It's a financial contract that is not tradable. Tradable to anyone actually who has access to that exchange. And it's not a tokenized exchange, it's an exchange where all sorts of assets are traded. Number one. So the US is already trying to position itself. Second thing is regulation. From a financial point of view, each country is always trying to get some advantage by being more tax-friendly, lighter regulated, and so on. Now with Brexit, if I would be the UK, and I would look at what you've just talked about, the EU and Germany, I would be the #1 country as UK to be super friendly to anybody who wants to set up a company to do ICOs. So how's that going to work? How's the EU going to mitigate that? I mean, or I'm going tomorrow to Cyprus and just gotta set up a company. So I can do exactly what the gentleman over there said, sell to 190 countries without being worried about it. Otherwise, the ICO market is never going to grow. So these are the sort of thoughts that
I will just answer the first question. The first question is self-regulation is not working, right? I will give you an example of, do you know how AML and KYC regime in 1988 developed? It was the banks that collaborated and they thought, okay, we need to come up with something. There are a lot of self-regulation mechanism that actually works. The question is, who has to enforce the self-regulation? That you can use a state mechanism, but you can create the regulation. I'm talking about a decentered regulation. The top-down approach means you are a part of the regulation also, and you put the enforcement power or function to the state. That actually mitigates a lot of issues, and also that gives you a say in the issuance jurisdiction and other issues. Regarding the second question, okay, you want to stay in, say for example, a small island, say for example, Bhutan. I'm giving you an example, there's no crypto valley. Have anybody heard about Bhutan? Yeah. Okay, so Bhutan believes in global happiness index, no GDP. You do a bank over there properly in Bhutan, no one will attack you because India and China, they are standing over there right now, trying to protect each other's territory. So you will be protected properly. But you have to issue, you have to convert the fiat, you have to pay the salary to the employees. The employees will not stay in Island of Man or Bhutan. You have to bring them somewhere and they can trace you. They can lock your bank account, they can restrict your passport. What you can do on that? They have power. If they're done so with Snowden and others, they can do, they have the power. The regulators are not stupid. And I would like to give to Nina now.
Yeah. Maybe one thing, don't shoot the messenger, right? So we didn't invent that whole thing here. We are just, telling you how it currently works. So I think we're the wrong ones to actually, argue for it. Indeed, quite the opposite. What we're doing in the Bundesverband is currently to collect all these pain points and then present them and try to get, at least those changed, which only depend upon the different technique that's used here, right? And that the law maybe did not foresee when it was invented 100 years ago. So yes, it's not perfect, and Germany is actually not pretty good in making itself with those regards as a good, competitive environment. So unfortunately, when there is EU law, we try to implement it even a little bit more stricter than necessary. And that's what we're seeing in this regulatory area a lot. And that's obviously what we don't like and what we're also trying to bring up to say, hey, we've got a huge crypto scene here in Berlin, a lot of startups coming here, even founders from abroad come to Berlin to found here their companies because they find the software engineers who like to live here. So why, don't we allow those people to actually do their business legally here in Germany? That's absolutely stupid. And we should at least try to create a level playing field for business in Germany compared to other EU countries.
Yeah. Maybe just one comment from people who are actually doing ICOs, not myself, but I've been talking to quite a few, and they tell me that actually Germany is the best country to do that and has currently the least practical regulatory limitations. What's your take on that? Compared to Switzerland, for example?
Well, I would say at least in Germany, we have a pretty clear view on what's required. So for specific financial instruments, you simply need a prospectus. So what? Write a prospectus, go to the BaFin, let it approve, and then you can legally offer whatever you want to offer. It's sometimes even easier than going for the other route, the software license token, where you are out of all the regulatory implications, because tax actually is even more difficult. And by the way, it's not true that you're clean and safe when you simply go abroad to Gibraltar, to I don't know where. Because if you're offering your tokens, those kinds of tokens in the EU, then the VAT is owed in those countries where the users are, right? And that really makes it difficult. It doesn't matter where you sit. And that's one of those things we're now trying to solve, because that's really, it's even more difficult and more expensive, by the way, to solve that issue than to comply with the regulatory things. Yeah. And so we're actually working, I think we will see the first prospectuses sometime soon.
Yeah, sorry, I didn't want